In our previous two lectures, we have already discussed regarding what exactly contempt of court means and how it originated and developed in the context of England and consequently how it came into the Indian legal system. And now we would like to discuss about certain important landmark judgments delivered in contempt of court cases. So the first important landmark judgment relating to contempt of court is the important leading case E.M.S. Namboodripad versus T.N. Nambiar of 1970, where the case remains a significant example of criminal contempt dealing with the delicate balance between free speech and judicial authority. E.M.S. Namboodripad, the then Chief Minister of Kerala, made disparaging remarks about the judiciary, accusing it of favoring the rich and being influenced by class interest. His statements were perceived as undermining public confidence in the judiciary, leading to criminal contempt proceedings. The Supreme Court in this particular leading case held that while freedom of speech is a constitutional right, it is not absolute. The court emphasized that statements that scandalize or bring disrepute to the judiciary constitute contempt of court. Namboodripad was convicted of criminal contempt and fined, offering the judiciary's role in preserving, affirming the judiciary's role in preserving its dignity and authority. And the next important leading case that relating to contempt of court is the Delhi Judicial Service Association versus the State of Gujarat, and that was a case of 1991, where exactly in this important leading case where the case dealt with criminal contempt arising from the unlawful detention and humiliation of a judicial magistrate by police officers. So the magistrate was handcuffed and paraded in public, undermining the dignity of the judiciary. So the Supreme Court in this important leading case, Delhi Judicial Service Association versus State of Gujarat in 1991, held the police officers guilty of criminal contempt and emphasized that actions that diminish the judiciary's authority and independence should not be tolerated. The judgment highlighted the judiciary's role in safeguarding its members from extrajudicial harassment and interference. And now we would like to discuss another important leading case and relating to contempt of court is Dr. D.C. Saxena versus Chief Justice of India, and that is a case relating to contempt of court and which was decided in 1996. So, in that particular case, as we found that dealt with disparaging remarks made against the Chief Justice of India, which were deemed scandalous and capable of eroding public confidence in the judiciary. Dr. D.C. Saxena was found guilty of criminal contempt for making baseless allegations against the Chief Justice. The Supreme Court in 1996, while delivering this judgment, reaffirmed that the judiciary must be protected from unwarranted attacks to maintain its authority and dignity. It held that freedom of speech does not grant individuals the right to malign the judiciary without evidence or justification. And now we would like to discuss another important leading case, and that is Supreme Court for Association versus Union of India, and which was decided in 1998, when this landmark judgment clarified the limits of punishment in contempt cases, particularly concerning advocates. In this case, an advocate was found guilty of contempt for misconduct in court. The issue revolved around whether the Supreme Court could debar an advocate from practicing sizing as a form of punishment. So the Honorable Court held that while it has the power to punish for contempt, it cannot debar an advocate from practicing such disciplinary actions fall under the purview of the Bar Council of India. The ruling drew a clear line between the judiciary's power to punish for contempt and the regulatory authority of professional bodies like the Bar Council of India, ensuring that contempt proceedings do not overreach their jurisdiction. So now we will go to another most important landmark judgment relating to contempt of court, and that is suo motu was taken by the Supreme Court, and that particular case is relating to Arundhati Roy in 2002. So, in this particular important leading case, as we found, Arundhati Roy demonstrated how personal opinions expressed in public domain could lead to contempt proceedings. Arundhati Roy, a renowned author, made comments criticizing the judiciary's handling of public interest litigation concerning the Narmada Dam project. Her remarks were perceived as scandalizing the court and undermining its authority. The Supreme Court held her guilty of criminal contempt for making statements that were contemptuous and lowered the court's dignity. And Arundhati Roy was fined as 2000 and faced a simple imprisonment term for 1 day, demonstrating the judiciary's intolerance for baseless and derogatory allegations. This case underscored that while individuals have the right to criticize judicial decisions, such criticism must be constructive and not disparaging. And now we would like to go another important leading case, that is R.K. Anand versus Delhi High Court, and which was decided in 2009. So, in that particular case, we found about the importance of this case from a sting operation that exposed a senior advocate attempting to influence a key witness in a high profile hit and run case. The Delhi High Court initiated contempt proceedings against the advocate for interfering with the administration of justice. So the Honorable Supreme Court upheld the High Court's finding, observing that any attempt to subvert judicial processes constitutes criminal contempt. This case underscored the judiciary's responsibility to preserve the integrity of legal proceedings and ensure that justice is not compromised. And now we would like to discuss another landmark judgment, and which is famously known as Subrot Roy Sahara case, and which was decided in 2014. So, in that particular leading case, as we found the Sahara group's high profile case involved civil contempt for failing to comply with a court order directing the company to refund money to investors. Subrot Roy, the chairman of the Sahara group, was held in contempt for non-compliance and faced incarceration. The Supreme Court's actions in this case demonstrated the judiciary's determination to enforce its order and protect investors' interest. It also highlighted how civil contempt proceedings serve as a tool to compel compliance, particularly in cases involving financial disputes. And another most important leading case, that is relating to one of the sitting judges, C.S.Karnan case, which was decided in 2017. And this particular important leading case, that which was decided in 2017 by the Supreme Court, and in particularly Justice C.S. Karnan was a sitting judge. So, in that particular case, as is one of the most dramatic examples of contempt of court in India, Justice Karnan, a sitting High Court judge, made several public allegations against Supreme Court judges, accusing them of corruption and caste discrimination. His behavior was considered unprecedented, as he refused to cooperate with judicial processes and continued to scandalize the judiciary. So the Supreme Court initiated suo motu contempt proceedings against Justice Karnan, ultimately sentencing him to 6 months of imprisonment for criminal contempt. This case was historic as it involved a sitting judge of a high court being convicted of contempt, demonstrating that no individual, regardless of their position, is above the law. And now we would like to discuss another most important and significant leading case, and that is the known as Prashant Bhushan's case, which was decided in 2020. So, in that particular leading case that is famously known as Prashant Bhushan's case and widely discussed case, activist and lawyer Prashant Bhushan was held in contempt of court for his tweets criticizing the judiciary, including remark about the Chief Justice of India riding a motorcycle during COVID-19 pandemic. The tweets were considered to undermine the authority of the judiciary and harm public trust. So, Honorable Supreme Court convicted Prashant Bhushan on criminal contempt, reasoning that his statements could diminish the reputation of the judiciary in the public eye. However, the court imposed only a symbolic fine of rupees 1, showcasing judicial restraint while upholding the principle of accountability. This case reignited debates on the limits of free speech and the scope of contempt laws, especially in the digital age where social media can amplify criticism. So, now we would like to discuss the very significance of contempt of court in India. So, in particularly, as relating to the significance of contempt of court, we would like to discuss again the important leading case and that relating to that these landmark cases that we have already discussed illustrate the critical role contempt laws play in upholding the judiciary's authority and ensuring the smooth functioning of the judicial system. Whether dealing with civil contempt arising for non-compliance or criminal contempt involving acts that scandalize the court. These cases demonstrate the judiciary's resolve to protect its integrity. The doctrine of contempt serves as both a shield and a sword. It safeguards the judiciary from unwarranted attacks while ensuring accountability for its adults. However, it must be exercised judiciously to strike a balance between judicial dignity and democratic freedoms, ensuring that rule of law is upheld without stifling legitimate criticism. So, in particularly now we would like to conclude our valuable lecture on the landmark judgments relating to contempt of court. So, in the conclusion, that already we have discussed in the leading case relating to Justice C.S.Karnan, a High Court sitting judge being held guilty of contempt of court, and also Prashant Bhushan's case relating to using social media and the Twitter in relating to the very tweet on the Chief Justice of India and how he was punished symbolically with rupees 1 only by the Honorable Supreme Court of India. So, in the conclusion, we could like to discuss the judiciary's authority and integrity are indispensable to maintaining the rule of law in any democracy. So the landmark cases on contempt of court in India underscore the importance of balancing judicial dignity with democratic freedoms such as the right to free speech and expression. These cases highlight how contempt laws are as a safeguard against actions that undermine the judiciary's role while ensuring compliance with its orders. As these precedents demonstrate, contempt laws must be applied judiciously to protect the judiciary's honor without stifling constructive criticism. By upholding the principles of accountability and respect for judicial processes. These cases continue to shape the evolving relationship between the judiciary and the public. So we have to conclude our valuable lecture on discussing what exactly contempt of court and how it was being taken by the Supreme Court of India. So, in that context, almost we have discussed 9 important leading cases, such as E.M.S. Namboodripad versus T.N. Nambiar in 1970, then the Delhi Judicial Service Association versus State of Gujarat, then the third most important leading is Dr. D.C. Saxena versus Chief Justice of India in 1996. Then the Supreme Court Bar Association versus Union of India, which was decided in 1998. Then another important judgment delivered by Supreme Court relating to the renowned author Arudhati Roy's case in 2002. Then R.K. Anand versus Delhi High Court decided by Supreme Court in 2009. And another most important case relating to civil contempt is Subrot Roy Sahara case of 2014. And the most important leading cases Justice C.S.Karnan's case 2017 decided by the Honorable Supreme Court of India as Justice C.S.Karnan at that time was a sitting judge of the High Court. And the most important leading case relating to contempt of court, in particularly the case of Prashant Bhushan's case in 2020, which almost highlighted what exactly contempt of court means and how it relates to freedom of speech and expression when it comes in conflict with the fundamental freedom, that is freedom of speech and expression, as it is provided under part 3 of the Constitution under Article 19, Clause 1, Subclause A of the Constitution of India, and how the case determines the use of social media and the tweets by the renowned lawyer and advocate Prashant Bhushan.